Live from the fishbowl. It is your favorite legal podcast, The Law of the Land. Folks, if you are looking for lawyers in three-piece suits, you come to the wrong spot. We are real lawyers talking real. I am your host today, Scott Kuboff, with the law firm of Lowe Trial Lawyers. To my right is my partner,
Kyle Melling.
And to my left is the always funny and intelligent and young
Ryan H. Fisher.
All right, fellas. We got a great podcast cooking for you. We're going to do dog bites, bar fights, and party nights.
Are we doing that now or when the podcast is over?
Do you want to start now?
We'll wait till the appropriate time.
Wait till the appropriate time. Kyle, what do you think? Start now?
I'm always down to have a drink.
Okay.
While podcasting.
All right. In that case, our podcast is not brought to you by Coors Banquet Beer, but that's just what we happen to have in the fridge.
Do we have a bottle opener?
It's a twist off. It's a twist off.
Here's your Lowe
Thanks.
Trial Lawyers koozie.
Perfect.
Man,
We don't want it
thank you.
getting cold or warm.
So we have a new number. It's 440-LOW-LAW, but when shit happens, give us a call. All right, fellas, cheers.
The koozies really kill the clink.
It does kill the clink.
There
we go.
Let's
All
get
right.
it on.
So, as three fellas at the law firm, we have something in common. Kyle, you want to take a guess? Maybe I shouldn't ask Kyle this question. Ryan, you want to take a guess?
I was going to say a full head of hair, but that's not going to
Just
fly.
always picking on me.
We got doggos.
Well, we do have dogs.
So why don't we go around the room and let's talk about our dogs. Kyle, I think you got the youngest. No, maybe Ryan does.
No, my dog's only 3.
Okay, Kyle, you start anyways.
Well, my dog is 9, almost 10. He's a Wheaton Terrier, sometimes known as a Wheaton Terror. And he's maybe the most experienced in the room in terms of what we're going to talk about today.
Yeah, you did have a run-in with the Postal Service.
You know, there was never a confirmed bite of the postman, but they do no longer deliver mail to my house. There were a couple confirmed nips at the groomer's office, though, so we can talk about that.
And Ryan, your dog actually is somewhat famous.
My dog Edgar has a TV career. You may have seen him on the Lowe Trial Lawyers' most recent TV commercial. It really has gone to his big giant head. He doesn't like to leave the house without his sunglasses now. And all the dogs on the street want to play with him now that he's a famous TV star. He's a half American Bulldog, half Staffy, and he's awesome.
He is, in fact, awesome. I always joke around, call him Skinny Jeans, because he has little teeny tiny back legs and some prison muscles up front. I, of course, have probably the oldest dog in the room, I think, Norman. He is a 14-and-a-half-year-old Wheaton Terrier. He is blind and deaf and still kicking and awesome. So now that we're talking about dogs.
And he peed in my office last week.
And he did. He did do that. So now that we're talking about dogs, let's talk about a common claim that we handle in the office, and that is a dog bite claim. So, Ryan, why don't you take it away? Tell me about the 2 types of dog bite claims that we can pursue.
So when we file dog bite actions here at Lowe Trial Lawyers, we always allege 2 causes of action. And we'll get into these, but we allege strict liability as well as a negligence cause of action, because the negligence cause of action allows us to pursue punitive damages if the facts provide for that. I often tell people the hard part about dog bite cases isn't winning them, it's collecting money on them. Dog bite cases are one of the last types of cases in Ohio that is still controlled by strict liability. Strict liability means you don't have to prove negligence. In virtually every other tort case, like a car accident or a slip and fall, you have to prove that the defendant committed some act of negligence. In a dog bite case brought under the statute for strict liability, you do not have to prove that. You can pursue the owner of the dog, the keeper of the dog, or the harborer of the dog if the dog caused you injury, irrespective of whether there was any negligence on the part of the owner of the dog. So they're kind of easy cases to win, but there are exceptions and there are defenses.
And we'll get into those, and as well as the definition. But let me ask you this, and one thing that I would kind of talk to folks when I started my career doing criminal defense about what strict liability is, and how I explained it is, if you got pulled over for doing 35 and a 25, and the officer came up to you and said, "Hey, do you know why I pulled you over?" And you say, "No, I don't." And he said you were going 25 and a 35, or excuse me, 35 and a 25. There is no intent there. It's just the fact that you're doing an act that's prohibited that makes you liable.
Correct.
Okay.
Correct.
And so in Ohio, the statute is 95528B that makes owner, harbors, keeper liable for damages.
Correct. I was going to say the other cause of action, if you choose to pursue a negligence cause of action instead of strict liability, then you have to prove that the owner or keeper or harborer of the dog committed some act of negligence. But if the facts are there and the conduct of the owner is very egregious, or if the dog is a known vicious dog, you can get additional damages by way of punitive damages in that scenario.
Now, Kyle, there are a couple of exceptions as it relates to the statutory cause.
Certainly, there are two main exceptions to the statutory cause. I'll start with the second one because it's a little easier to understand. If you're teasing or tormenting or abusing a dog, and the dog bites you, you don't get to hold its owner liable, at least not strictly liable under the statute. The definition of teasing, tormenting, and abusing the dog is very gray and unclear, but it's kind of like other things. You know it when you see it. The other exception is committing or attempting to commit a criminal trespass or another criminal offense. So a lot of times people say, well, it was on my property. So, that mailman got bit, but it was on my property. So that's not on me, right? And no, a mail delivery person or somebody delivering a FedEx package or a UPS package on your property is not committing a criminal trespass. A criminal trespass is defined by knowingly entering a piece of land that you don't have a privilege or you don't have the right to access. Somebody delivering a package to your house does have, a presumptive right to walk up to your front porch and drop a package off, unless you very clearly put signs up that say, do not enter, dog here, leave packages at the front, gate or whatnot. So those are really the only two exceptions. And then, of course, if you're on the property knowingly committing some other criminal offense, such as attempted burglary or robbery or whatnot, and you get bit by a dog, you don't get to hold the dog owner liable for that.
So what about if a owner puts up a sign that says "Beware, dog," and you walk onto the property and you get bit by the dog?
Yeah, I don't think that's enough. Because if you have a right to be on the property, if the owner invites you onto the property, if you're delivering something to the property, the "Beware of dog" sign I don't think gets you there. I think it really has to be you knowing that you're criminally trespassing on that property. You're not allowed to be here and you're still going on that property and then the dog bites you. Now that's on you. But just the "Beware of dog" sign, no, I don't think that does enough.
I agree. I think if that was the intent of our legislators, they would have put an exception in the statute for somebody who warns about a vicious dog or "Beware of dog."
Now, would that be a different analysis under a negligence theory?
It could be. I think it would have to depend on the facts. I think it might be different to have if the sign said "No trespassing, vicious dog" or something like that. I think you might have a better argument. kind of an assumption of the risk type argument.
I was just going to say that. Yeah.
You had a case involving a beware of dog sign, didn't you?
I had an interesting case, and this is a good real life example. I had an Amazon delivery worker, and now there was a dispute over what the instructions were. But the defendants claimed that the instructions in the Amazon app said, "Do not go past the carport. Leave the package at the side door." My client claimed that the Amazon instructions said, "Leave the package at the side door." It was a very large house. She walked up. There were 3 side doors on this house. I don't know why she didn't leave it at the first side door. The second side door, she said, was covered in garbage, like it was garbage day and it was waiting for the garbage truck to come pick it up. So she didn't want to leave the box there. So she proceeded all the way into the backyard and to the third side door. And it was a screen door, and a small child, opened the screen door, excited about the package. The dog popped out and bit my client. And we fought about that. Now, what I was able to show through a subpoena to Amazon was that the instructions had been changed after the accident. Amazon couldn't tell us what the instructions said before and after, but they could show that the owner had logged in and made modifications to those instructions afterwards. But I was going to say on the common law claim, on the negligence claim, if you had the beware of dog sign, then you do have an assumption of the risk defense that you don't have under the strict liability statutory claim. So you could argue, if you were pursuing a common law claim, that if you saw that beware of dog sign and you still were like, I love dogs love me, and then you get bit, you probably lose out a little bit on your common law claim, but you'd still have your statutory claim.
Lately, with all of the deliveries, especially Amazon, I am seeing a big uptick in Amazon drivers calling us with dog bite cases. About 2 years ago, I had one particular Amazon driver who got bit 3 times in the course of about 5 weeks from 3 different customers. So all you Amazon drivers out there, be careful.
Did that driver have meat in his pockets? Or
That's what I thought the same thing. Are you showering in gravy before you go to work?
All right. So it's not always the owner's responsibility, right? There's other people we could look at as well. Let's say the owner is a person who may not be recoverable, right? A tenant in a rental facility, apartment complex, he or she doesn't have any insurance. Are there other people we might be able to go after?
sometimes.
Okay, sometimes. One of those times.
All right, so let's just talk specifically in a rental complex where we have common areas and we have private apartments, right?
Mm-hmm.
If the landlord, the owner of that apartment complex, allows dogs into that property, and then there is a dog bite in the common area of the property, there are times, given that we are able to allege that the owner of that apartment complex is a harborer for the purposes of the statute. It's a tough one, but it's something that we can do. Other times, say it's a house or a duplex, but the owner allows a knowingly, scary dog, big dog, vicious dog to live on the property, and then that dog bites somebody out front. Sometimes we can argue that the landlord themselves is also a harborer, because what's the definition of a harborer or a keeper of a dog? It's somebody that owns the premises where the dog lives. Judges are a little bit weary on that one. It's a little harder to, get the judge to swallow that, hey, I own, 100 different houses, and yes, I let people have dogs there, and you can't hold me liable for that dog. It's the responsibility of the owner of the dog to take care of that. The easiest way that I would give advice to landlords to solve that is, if you're going to let them have a dog, make sure they confirm to you they have renter's insurance that covers their dog in case their dog bites someone.
Yeah, absolutely. A harborer is someone who has possession and control of the premises where the dog is, and they acquiesce or agree to allow the dog's presence there. And I understand there's a lot of times where in the lease it says dogs aren't allowed, notwithstanding the fact, there are definitely dogs on the premises. Ryan, if you were investigating a claim where you found out that the landlord did not allow dogs per the lease agreement, but there were definitely dogs on the premises. Say we'll call it like a two-family home. How would you go about investigating whether or not you could pursue a claim against the landlord if the bite occurred, say, in the front yard?
Well, the fact that the dog isn't permitted under the lease certainly is a negative for bringing a claim. But if the landlord was aware that the dog was there and didn't enforce his or her lease, I think it gets you past that issue. It gets you to the point of did the landlord know or have reason to know that this dog was dangerous or vicious or had bitten people in the past. So a lot of times you can get that information from the county dog warden or the health department. Most dog bites, I like to think, have been reported. If you go to the emergency room with a dog bite, oftentimes they will report it to the Board of Health. So it's helpful if the lease allows dogs, but if it doesn't, that's not the end of the road.
Yeah. And the other aspect of the definition is a keeper. And that's someone who has physical control of the dog and maybe takes care of the dog, even if it's temporary. So Kyle, you take Finney to the groomers, where he's been known to eat people's legs.
No, just got a little scared.
Are you liable when Finney bites the groomer?
Yeah, this is one of the interesting exceptions. It applies to groomers, veterinarians, basically anybody you turn your dog over and you give them control of your dog. If your dog then bites them, they can't hold you liable as the owner because they were the keeper at the time that the dog bit them. I had a case a number of years ago where actually a volunteer at a dog kennel was bit in the face by a dog, and we were not able to pursue a statutory claim because at the time she was the keeper of the dog. However, the owner of the dog did not inform this. It was actually a boarding facility. Did not inform this boarding facility that this dog had bitten a number of people in the past, so they weren't adequately warned about it, and we were able to pursue a common law claim in that situation. And because we had evidence of the prior bites, we were also able to pursue punitive damages in that situation. But that also puts liability on people that, the keeper liability puts liability on people that are walking your dog or people that are potentially a person that you put in charge of letting your dog out in the middle of the day. If that dog gets away, you can then hold that person liable as the keeper of the dog under the strict liability statute. So you got to be careful about who watches your dog too. Make sure everybody's adequately insured.
So, Ryan, under the statute, we're not just talking about dog bites. I mean, certainly that's what we use this statute most often for. But does it cover other types of injuries a dog may cause you?
Oh, a dog doesn't have to bite you. I've had a couple of cases where the dog would get all excited, run out of the house, and jump up on a passerby. Not trying to be vicious, not trying to bite, just, hey, I'm so happy to see you, and jump up and knock the person over or scratch them real bad. That also falls within the statute, and there absolutely can be liability for a dog that behaves like that. And not only dogs, the statute isn't limited to dogs. It can be virtually any animal that you have as a pet. So if you're a goat, I think you have a goat, Kyle. If your goat runs out of the house and bites somebody or jumps on somebody, there can be liability for that as well.
If a cat chases you down the street.
A cat, yep.
No, I had two cases, I believe, where there was non-bite injuries. One was a group of cyclists who were out on a group ride, and the dog took off from the yard and entered into the group ride, and a bunch of people went down. And then there was another time a client was talking with her neighbor, having a very pleasant conversation, and the dog was playing fetch and kind of was all excited, running back up and ran into her knee and blew it out. So you definitely can use that statute for other types of injuries. All right, we are going to do...
Let me say one thing before we change subjects. as kind of a public service. If you own a dog, make sure that your homeowner's or renter's insurance covers you if that dog causes injury to somebody. Different insurance carriers have different policies. Some exclude a dog unless you buy particular coverage or a rider to cover that dog. Some will exclude certain breeds of dogs. Some will include a dog if he has a history of biting someone in the past, and some have no exclusions at all. So check your policy, call your agent, make sure if you have a dog, even if he's the nicest, friendliest dog in the world, because like we just said, he doesn't have to bite somebody. If he knocks somebody over, you're going to be on the hook for that. So make sure you have coverage for your animal. All right.
Okay. So let's do a rapid fire session here. Statute of limitations on the common law claim. Ryan, number of years.
The statute of limitation on a common law claim is 2 years. The statute of limitations on the statutory claim, I believe, is 6 years.
He was going to ask me that one to try and stump me.
That was part of the rapid fire.
Well, you didn't you didn't start talking, so I kept
You were
going.
supposed to say 2 years, and then Kyle's like, yeah, I agree with that.
Yeah,
and
it's
then I
2
would have said,
years.
you guys are so smart.
Oh.
And then I would have tried to stump you
Try it
with
again.
the
Maybe Kyle
statutory.
wasn't listening.
I was looking in my notes to see if it was down here.
No, we're not. No, we're keeping this in. They're not editing it out. It is what it is. But yeah, actually, that was something that came to light a few years ago. A woman came to me with a dog bite claim, and the statute on the common law actually had already run, and we were able to still pursue it under the statutory claim under the 6-year statute of limitations. Okay, I think we have accomplished everything we want to talk about as it relates to dog bites.
That was it for the rapid fire. One question.
Yeah, well, I mean, you really ruined it. I'm not gonna lie. There was going to be more, but you had to.
That's
just...
what happens. I didn't come to the rehearsal.
All right. So we are done with dog bites. Let's go to something that Kyle knows nothing about: bar fights. Kyle, you went to the prestigious Harvard of the Mac, Miami University.
The Ivy of the Midwest.
Where you learned how to pop collars and certainly did not get into any bar fights.
I might not have gotten into any bar fights. I think I started a few, but
Yeah, I've been known to instigate.
Women fighting over you?
yeah, exactly.
They were definitely in a bar then, and it was definitely around closing
Their
time.
ex-boyfriends coming up to me.
Okay, so
Back when I had a full head of hair.
and just to continue the continuity of last one, we are talking about drink bars for this.
They're like moo cows.
Drink bars.
Drink bars.
Not to be confused with coffee bars,
Juice bars.
juice bars.
But these are drink bars.
These are alcohol drink bars.
So
Kava bars.
when is a bar responsible for a patron's injuries? Let's start with Ryan inside the bar.
Ooh.
When is a bar responsible for a patron's injuries?
Are they
They
responsible?
they can be if you are walking to the bathroom and the stairs collapse and something like that happens. I think you're talking more about alcohol-related injuries.
We are talking drink bars.
Okay,
Yes.
so, very limited circumstances. If you walk, as an adult, if you walk into a bar and you drink and you get yourself intoxicated and you do something stupid or you fall down or you drive your car into a tree, that's on you. There are very limited circumstances. None come to mind right now. I'm sure Kyle will disabuse me of that. But none, if you get yourself drunk in a bar and you hurt yourself, I don't think there's a remedy for that against the bartender or the bar owner.
Can I just? We are talking to normal folks out there.
Mm-hmm.
Disabuse. That's a 50-cent word. Can you explain that?
I think Kyle will while he's sitting there on his computer looking for some way to bring an action, he will prove me wrong. But most of the time, the drunk patron has no recourse against the bar.
Yes, I think I agree with you, and I think that's true. Even outside the bar, right? If you're voluntarily intoxicated, you don't have a claim against the bar owner. I mean, outside of a typical premise case. If there's something unrelated to the service of alcohol. Kyle, can you think of anything else where the bar owner may be liable to someone for what's going on inside with drunk patrons?
Yeah. A couple different scenarios come to mind. The one that jumps out at me first is a bar can actually be held liable if they knowingly serve an intoxicated person, or a noticeably intoxicated person is what the statute says, and then that person causes personal injury, death, or property damage to someone else inside the bar. We usually think of that in terms of dram shop liability, which we're going to jump into in a minute, where an intoxicated person drives their car away. But if that person inside the bar is noticeably intoxicated, the bar continues to serve them a bunch of liquor, and then they get in a fight or they assault someone, the bar could be held liable. The other place that bars have been held liable is for negligent security, with a few caveats. But when, if you have a bar and that every single weekend it gets out of control, it gets out of hand, fights start, and you don't do anything about it, you don't hire security, you don't limit the amount of people that come into your bar, you don't get a bouncer at the front door, and then that keeps happening and somebody gets hurt, they can hold you liable for that in some circumstances.
Yeah, no, it's those are the fun punch palaces. Those types of cases that you have.
The fun punch palace.
Says the man from Youngstown, of course.
Speaking of Youngstown, I would say, and in fear that we might not know the answer to this, but we'll just throw it out there. We're spitballing here. So as a man from Youngstown, I remember the days that you would go and get your YSU library card as a junior in high school, and then get to go to certain bars that rhyme with Schmurny McDougal's and Schmogos, and you would be able to get in with your YSU ID. Of course, we were in high school, and we had big X's on our hands, but we still got served nonetheless. Do you think, Ryan, that bars in that situation would find themselves in trouble if an underage patron went out and hurt someone?
That's a horse of a different color, and the answer to that question is yes. A licensed bar or tavern is obligated to make sure that they serve legal people. When they get that liquor license, that they are entrusted to follow the law, and the law is you have to be over 21 to serve alcohol. So they have an absolute duty to check IDs and make sure that the person that they are serving is of age. And if they are not, and that person becomes intoxicated and injures himself or is killed somehow, that bar, I believe, could be held liable in that scenario.
And what about to the underage person that was served? Would they have a claim against the bar in that situation? I mean, I know the answer is no if they're an adult.
Right. I believe that they do. But in all honesty, I'm not certain about that.
Al, do you have any thoughts?
No, I need to. What's the question again? I'm going to edit that one out.
If you're going to edit. No, we're not going to edit that one out. We're going to keep it in. Underage person.
Mm-hmm.
So they go into a bar. It's pretty well known that underage people are served.
Yeah.
That underage person gets drunk at a bar.
Bars in Youngstown. Got it.
Yeah, I mean it happened. I'm not casting any stones. It was a core memory of mine growing up, and I remember the day that you became 19 and you got to go to a different bar uptown, and kind of away from the high school kids. But it was widely known that you could go into these bars and be served underage if an underage person was overserved, and they left the bar and drove into a tree and were seriously injured. Do we think we have a case against the bar for knowingly serving an underage person?
Yes.
Okay.
In Ohio, we do.
And how would we do that?
It's a statutory claim, I believe. If you knowingly serve an underage person and then they go hurt themselves, I think you can hold the bar liable for that.
Is that under the furnishing
Yeah.
statute? Okay. I don't know that one off the top of my head, but I think that is kind of also like the nuance, if you will, with respect to let's remove the bar from it and say we're at an outdoor party at our house. Ryan, if you're a social host and let's press pause on the minor issue.
Mm-hmm.
An adult at your house is gets drunk and leaves and hurts someone or themselves. Can you be held responsible?
I don't believe so. A social host is not held to the duty of a bar or a license holder. Again, assuming that person is an adult, I don't believe the social host has any liability in that scenario.
Kyle, a minor in that situation, under the age of 18, social host.
Yes, 100%.
Responsible for injuries caused by the minor?
Yes.
What about injuries to the minor?
I don't know.
Okay. True facts. You are responsible for injuries caused to a minor if you are a social host.
That's what I thought.
That's why they say parents who host lose the most,
Lose
right?
the most, yeah.
Now, Ryan and I were talking about this in preparation. And what
Hard to believe we prepare for this.
and it was actually something that I made a video about this a number of years ago, and I was very specific saying minor. And the question became, okay, well, what about an adult? Someone who is 18 but not of age, right? And so the question became, hey, that doesn't make sense. Like, how could a social host not be held responsible if they were furnishing alcohol to someone that they knew was 19? So, Ryan, what did our research?
Well, so it seems like, and we know in the law what seems like isn't necessarily the truth, it seems like that social host should be held to the same standard as serving a minor. But they are not. Because that, even though they're a minor with regard to getting alcohol, or they're not legal to drink alcohol, because they are not minors, ergo they are adults, they have made their own decision to become intoxicated, and it is not the fault of the social host. So a social host is not liable for injuries sustained to a 18, 19, or 20-year-old underage drinker.
That is, of course, unless it is shown that you could prove that social host violated the statute of furnishing alcohol to an underage person,
fair,
right?
Fair, yeah.
And then there is a statute which we probably should have figured out in our preparation that you can pursue civil claims against individuals for commission of criminal acts.
Yes, also true. That's actually a great point.
Sometimes it pays to be lucky than good.
Sometimes you can also hold parents liable for the criminal acts of their minor children, up to a very limited amount. I have a twist, since you're throwing twists at me.
Okay.
What if it's an underage person, under 18, so a minor, but it's their parents at someone else's party furnishing them alcohol?
So it's a minor,
Under 18.
okay, and they're at their friend's house.
They're at a party hosted by a social host.
And their parents are there.
Their parents are there.
And the parents are furnishing their children alcohol.
And then their children drive off and cause an accident.
I think mom and dad are responsible for that because mom and dad are allowed to give their children alcohol.
Exactly.
They would be responsible for that.
That would be a very good bar exam question.
God, I'm glad I don't have to do that again. All right. Do we think that we have talked as much as we want to talk about bar fights and party nights?
Have we talked about dram shop, or is that next on your list?
We kind of glossed over the dram shop.
We did, because we were getting into the dram shop's a little simpler, right?
Yeah.
It's if a bar serves a noticeably intoxicated person alcohol, and they know that person's driving, right? The bar has to have knowledge that person's driving. Am I right on that?
You do have to prove causation between the intoxication and the injury. I'm not necessarily sure that they need to have notice that the person is driving.
Yeah, I think the way the dram shop law is written is that it's just if they serve a noticeably intoxicated person, and then that person goes off and causes someone else injury. So I don't think in Ohio they have to know that person is driving.
I agree with you.
That bodes some
do
interesting
not.
questions, though. What if they stop the person from driving, but then the person runs off and hurts themselves?
I think you probably have somewhat of a defense, at least.
I think you have an intervening event there that may break the causal
That's a good point.
connection. One of the things that a lot of people don't understand about holding a bar liable under the Dram Shop Act is the drunk, the person who was overserved, has no remedy against the bar.
Yeah.
It is for that innocent bystander. It's for the kid that runs out to get his ball and gets hit by the drunk, or for somebody who wasn't in the bar being served.
Or even if the drunk crashes their car and the passenger
Yes.
who was at the bar with them, they would also have a claim against the bar.
They're difficult cases because the burden of proof is so high. The issue is not should they have known the person was drunk. It's did they know the person was drunk? And having handled some of these cases, the type of evidence that we get are surveillance videos, security videos from the bars, credit card receipts, things like that show that this guy bought 27 beers in 2 hours, and at some point the waiter or the server or the bartender should have known. And also, these bars are supposed to provide training for their staff, for their bartenders and their servers, to train them to recognize somebody who's intoxicated. It becomes very hard if you're at the Rocket Mortgage Arena and you've got these different guys selling. Those are very difficult cases to show.
You know, every one of these bars now has inside security cameras, though. I mean, it is not as difficult as we might think to show how much somebody has been served in one of these places.
Preserving it, getting it, if you think you might have a dram shop case, you need to act quickly because that surveillance video disappears really fast. And sometimes we need to get a court order. Sometimes the police, if it's really a bad injury, the police will get involved. But we need to preserve that evidence for our lawsuits.
Scott, how do they act quickly?
How do they act quickly? Well, they get a lawyer involved as soon as something goes sideways, right? If there's any doubt in your mind, you get a lawyer involved, and we take immediate action. We would send preservation letters, interact with the police, do whatever is necessary to preserve evidence, and start preparing the claim from day one. I do want to go back, though, for a second and talk about one aspect that maybe we're kind of glossing over, but it's a real conversation that we have with clients. I think there's a misconception of people believing that if you sell alcohol, you have to have some type of an insurance policy to cover your actions, right? It would be good, prudent business practice to have some type of liability insurance there. But in my experience, I have come into cases where the bar is just uninsured. And, what do we do for clients in that situation? Is there anything that we can do?
Well, first off, it is astounding to me that you can serve alcohol in a bar with a liquor license without insurance. But you absolutely 100% can. And a lot of bars do it. And it just seems like that's something that our legislators should take action on and require. If you're going to have a liquor license, you have to have insurance. As far as I know, the only thing in the state of Ohio that you need insurance for that is required is to drive a car. You don't need one to fly a plane. You don't need one to run a business. You don't need one to perform surgery if you're a physician. Only to drive a car. I will get off my soapbox now. There was a question that you asked me before that.
Well, I mean, our legislature, they could be doing a lot of things right now.
Sure.
But they're
passing laws making it illegal for men to wear makeup.
Yeah.
So in many cases, any kind of case, we will turn them down if there is no insurance because it doesn't make sense to pursue a case where the client isn't going to be compensated. But there are exceptions to that. If the bar is a successful, ongoing entity and was just too darn stupid not to buy insurance, but they're making money and they have assets, we will pursue them in that scenario. I think most reputable, successful businesses do have insurance, but you'd be amazed. There are some that don't. So I wouldn't necessarily rule out a case because there's no insurance.
Yeah, there's a lot of investigation to do. One of the things I like to do and look at is to see if that bar has any loans against the bar. Because a lot of times banks, before they'll loan money, they do require there to be insurance. However, even when I found insurance, I found that a lot of those insurance policies have really, really, really egregious exclusions. For example, we'll pay for all damages except for those caused by firearms.
I've seen that as well.
I had to turn it.
I think you may have worked on that case with me.
I had to turn a separate one down as well. That was no firearm coverage for the bar that had metal detectors at the front, but allowed the guy to walk around the metal detectors.
I think, if I'm not mistaken, I've seen a policy that excludes coverage for injuries related to alcohol use, and this was for a bar. Basically, it covers you if you slip and fall, and that's it.
So, guys, our silent marketing manager over in the corner has asked a question. And that
why doesn't she ask the question? We can bring her in.
Okay, so quick question. So I was a bartender in a former life. So this is bringing up a lot of things to me that I've thought about. So I was thinking about how I'm not always necessarily, as the bartender, in control of how much someone has been served prior to stepping into the establishment where I'm an employee, right? And with that being said, that makes it a little bit harder for a bartender to keep track of. And also, I don't know if they're on some sort of medication where one glass of wine is going to affect them differently than the guy 2 bar stools down. And sometimes as a bartender, it can be difficult to discern, is that person intoxicated or are they just a weirdo? It can be really tough to control. So I guess that's kind of where my head is going and where my question was lying.
So the statute doesn't say that they have to become intoxicated at a particular establishment. It says that you can't serve them if they are intoxicated.
Noticeably intoxicated.
Yeah. Noticeably intoxicated. So whether the person had 12 beers before he came to your bar or not, if he's visibly intoxicated, you can't serve him. You can't even serve him that first one. But that is a problem with this type of litigation. And it's not uncommon for people to go from bar to restaurant and do that. And in those scenarios, we'll include all of them in the litigation and let them point fingers at each other. And that's a common strategy. And if you're not doing that as a lawyer, you're making a mistake because you're leaving some potential defendant out there that everyone can point their finger at.
The other thing is this, and I don't want to give the roadmap to all the defendants out there about how to defend these cases, but while we usually will include the name of the bartender, if we know the name of the bartender, the defendant, the true defendant, the one that's insured in the case, is the bar. And so the bar's defense there, when the bartender says he wasn't noticeably intoxicated, we then go to the bar and we said, what are your training? How do you teach your bartenders to determine if somebody is noticeably intoxicated? And there's all kinds of manuals on this. The state of Ohio provides a specific type of training that a lot of insurance companies require bartenders to get before they can serve drinks, that talk about all the various things that they can look for to determine if somebody is actually intoxicated. If the bar doesn't provide that training, it's really hard for them to make the defense that the person wasn't noticeably intoxicated. If the bar does provide that training, it becomes a lot harder for us. And that's where we lean on, hopefully, Snapchat videos taken by the person's friend and closed captioning video or CCTV cameras from inside the bar and other evidence of their intoxication.
I have one more curveball to throw. So say, for instance, you're at an establishment that is a bottle service, right? So does that make any sort of difference when it comes to those kinds of cases, right? So as a bottle service server, you're really, in theory, bringing that bottle to the table. And at that point, how are you really in control of how much people are actually consuming?
I'll let Kyle handle this one because he is a bougie enough man that he would probably go to bottle service restaurants.
They have
or
bottle service in Youngstown? They throw a bottle at you.
I will have you know, I have only ever been to a bottle service establishment once, and both of you were right next to me.
Where was that?
Was that in Phoenix,
It
Arizona?
was in Phoenix, Arizona.
Actually, folks, I was back in bed sleeping.
Oh, man.
Like a normal.
We have a video from that evening.
responsible adult.
I guess you were.
We do have a video from that.
That's a good question.
I
Well-
would think. I mean, they have a liquor license, right? I mean, you have to have a liquor license to sell.
do
it.
bottle service, you actually have to have a separate type of license. We don't need to get into the various different D1, 2, 3, 5 liquor licenses, but a bar that wants to do bottle service has to be permitted by the state of Ohio to sell open containers of spirituous liquors and give it to them, which requires at least some heightened element of supervision. But again, no insurance required.
Is there any reason to think that would change the liability against the bar?
I don't think so.
I don't think so either.
If they serve a bottle of vodka to an visibly intoxicated person,
maybe they argue that it's a notice issue, right? So then you have the cameras where the bottle service waitress drops the bottle off, and then the stumbling drunk stumbles in and sits down at the reserved table and starts drinking the vodka directly.
they weren't drunk when I gave them the bottle of vodka. I don't know what happened.
I'd still take that case though, because I would argue
would
if
as
you're
well.
going to be serving open bottles of liquor, you should be supervising who's drinking the open bottles. of liquor.
100%.
definitely.
It's a heightened duty. I agree.
All right. Why don't we
It
move?
seems like our board operator has spent a great deal of time in bars. I don't know.
Were you a bottle service waitress?
I sure was.
Did you put the sparklers in it?
Absolutely.
Oh man, you'll have to take me to that bar.
Hey, I had to pay for this marketing degree somehow, right?
All right, let's move on. We are going to transition to our favorite segment, your favorite segment, certainly not the insurance company's favorite segment. Can you sue? Kyle, tell us, what is Can You Sue about?
All right, in Can You Sue, we watch a video of somebody getting hurt in some way, somewhat comically, and then we discuss any and all potential liability and if they could sue. Let's cue up that video.
You gotta sit down when you sing.
I gotta sit the fuck down.
All down.
Get fucking there. DJ Chipper in me. Oh, I guess I better sit down.
All right, we got our dude here. Good doggo.
I guess I better sit down.
Okay, wow, that one hits close to home.
It certainly
Was
does.
that your kitchen? So that guy calls us. He regains consciousness. He staggers over to his phone and he calls us.
Who's he going to sue?
Well, that's the question. So,
Well, it was a private party, so we'd be talking social host liability in terms of his intoxication. He's the intoxicated one, though, right? So he can't hold the party liable unless they served him something he didn't know about.
What about the good boy, the golden, that tripped him up?
I mean, I was thinking about that. I hadn't gotten to that point yet. It does look like that dog maybe possibly caused him injury.
I think the dog was standing still doing nothing, and he walked into the dog.
I think we need to look at 955.28. I think that Scott might be onto something.
I don't think that dog did anything to cause him to fall other than be there.
I don't know that.
I don't know that the dog needs
I don't
to.
need that. There needs to be like. I mean, you would think there needs to be some kind of affirmative action, right? Like
don't need
running into
Right.
The statute says
owner, harbor
keeper of dogs liable in damages for any injury that is caused by the dog.
Okay, so it's so the issue then would be proximate cause. Did the dog cause this drunken sot
Well,
to fall and crack his head on the cabinets?
but for the existence of that dog, does he fall over? I think we need to watch again.
Yeah, can we get that back up?
Roll the tape.
One thing I do want to ask is, of course it's Pittsburgh. Of course this is somewhere in Pittsburgh.
I saw the pit mug, yeah.
All right.
I mean, at least they're not listening to Renegade. That's all I have to say.
I mean,
about
I do
that.
appreciate that he said maybe I should sit down. Looks like the host, we'll guess he's the host, is like, hey, yeah, maybe you should sit down, Dad. Nope. Gonna party.
You know, for all we know, this is the guy's dog.
It's true.
It's true.
And he's a
Oh,
heart.
he's giving him a scratch. Oh,
In that moment, by the way, does he become a keeper of the dog? He somewhat takes control of the dog there.
oh, he got an air guitar solo.
So we'll assume
Yes.
we'll assume that he's a guest in this house. We don't really
I think that's
know.
an appropriate assumption to make for our purposes.
And we'll assume that wasn't his good boy.
Well, we will assume that is, in fact, a good boy.
Oh, he is a good boy.
Oh,
So to answer, ouch.
What about the thing where he says, "I guess I should have fucking sat down"? Is that an admission
is that a tacit admission?
that it wasn't the dog's problem?
What if the dog had previously tripped a drunk guy and caused him injury?
Can you sue? I'll say yes.
I probably
Can
don't.
you win? Would you take this case? If he comes into the office with that video, does anyone at this table take this case?
No,
No, he can't be that injured.
I can't take that case, even if he is that injured.
Yeah, I agree. I don't think the dog or the dog owner did anything wrong. Even with strict liability, I'm not sure the dog was the proximate cause of him falling.
The dog's not there. He doesn't fall.
And if you're on a jury watching that case,
No one is giving that man money.
But for the existence of the dog.
I'll give him an ice pack for his
I'll
head.
give him an icy light. That's what I'll give him. All right. Well, that sums it up and wraps it up for the second edition of Law of the Land. Everyday situations. Sometimes liability isn't obvious. If you have any doubt whatsoever and want some legal advice, Ryan has nothing to do but talk to people on the phone. Give him a call at 440-LOW-LAW. For more information about Lowe Trial Lawyers, check us out on the internet at lowfightwin.com. Until next time, I am Scott Kuboff.
I'm Kyle Melling.
I'm Ryan Fisher.
So long, fellas.
Cheers.